Hey everyone, welcome back to our channel. We've got a great video for you today to kick off our series, The Basics of. Today, we will be looking at the basics of resealing probate. If you've been an executor or you've met with an estate planning lawyer, chances are you've talked about probate. But the process of resealing probate is less well known. Let's get started and take a look at the basics of resealing probate. Just like not all wills need to be probated, not all probated estates need to go through resealing. In fact, very few straightforward, simple estates go through this process. This video will take a look at what resealing probate is, why some estates need it, and how to get it done. Probate has different names in different provinces. For example, in Newfoundland and Labrador, it's called letters of probate, whereas in Alberta, it's called a grant of probate. But no matter what it's called, probate is a process that validates the will and indemnifies the executor. It's a court order with the seal of the court. Therefore, resealing means to get another seal. This doesn't mean you go through probate in the same court again. It means you have the probate confirmed by another jurisdiction. Resealing can happen between any members of the Commonwealth. This means that a probate granted in one province can be resealed in another, or even in another country that's part of the Commonwealth. For example, a probate issued in Manitoba could be confirmed in Scotland, and vice versa. Resealing is needed when the executor needs to use the probate in more than one jurisdiction. This is why a lot of basic estates don't go through this process. All of the assets are in one jurisdiction. We know that probate is needed when there's real property in the estate. This could be a house, a cabin, a piece of land, or an asset like mineral rights. The executor would need to get probate in order to proceed with the estate. This probate is only valid in the jurisdiction in which it was granted. For example, probate issued in Alberta is only usable in Alberta. If there's real property outside of Alberta, the probate doesn't allow the executor to deal with it, even though it's part of the estate. This is because estate law is provincial and varies from one province to the next. The courts can only issue orders for their own jurisdictions, so orders for probate only cover one province. Let's look at a common example. Let's say there's an estate that's mostly in Newfoundland. This includes a house, bank accounts, investments, and personal items. Because there's real property, the house, the executor applied for and received letters of probate. The executor can now handle any of the assets in Newfoundland, but there's also a piece of property in Alberta. The Newfoundland probate doesn't include this asset, but the executor is still obligated to handle this property. So he applies to the courts in Alberta for a grant of probate. As soon as the grant comes back completed, the executor can deal with the property in Alberta. So if you know you need to get your probate resealed, how do you do it? Resealing a probate is very similar to the original probate application. Both applications are filed by submitting a series of documents to the court that tell the judge what kind of order you're asking for, who's involved, and what the value of the estate is. There are a few major differences though. For clarity, we'll refer to the jurisdiction where the original probate application is submitted as the first jurisdiction, and the jurisdiction where the probate is resealed as the second jurisdiction. The original application for probate requires the original will of the testator. The court keeps this will, so when the time comes to apply for probate in the second jurisdiction, there's no original will to send in. Instead, the court is informed of the original probate. In both applications, the executor needs to submit an inventory. This is a list of the assets and debts in the estate, and the value here is used to determine the court fee. On the original application, all of the assets and debts within the first jurisdiction are included. On the second application, only the assets and relevant debts in the second jurisdiction are included. For example, if there is a house with a mortgage in the second jurisdiction, only that asset and debt would be included on the application. This is important because the court fee for the first application is based on the bulk of the estate, and the application to reseal is based only on the assets in the second jurisdiction. This makes the fee for your second application significantly lower. Where to find us. You can visit us online at butlerwillsandestates.com, email us directly at chelsea@butlerwillsandestates.com, or visit our blog, estatelawcanada.blogspot.ca.